Well, welcome everybody. We're doing a music tech policy podcast today on a topic of pressing interest, I think you could say. And our guest today is Tim Capel, who is a lawyer, full disclosure, who I've known for a while, and is based in, are you in Louisiana? Are you
I'm
based
in New Orleans,
in
New
New
Orleans,
Orleans? Yeah,
Louisiana.
New
Yep.
Orleans, Louisiana, one of my favorite towns, where I went for my honeymoon. Um, and Abby North, who is runs a North Music Group and is familiar to our readers as she's been involved with a number of things we've done on the policy side. So, Tim, we're going to talk today about your case, Vitter v. Resnick. Vetter, I keep saying Vitter. It's Vetter v. Resnick. And
Bitter is another
Louisiana, that's an
Louisiana
important distinction.
in California.
Yeah, different guy, different guy.
Favorite
Um,
guy.
yeah. So why don't you tell us a little bit about the case and how you got to be here?
Yeah, well, I mean, Chris, first of all, thank you for having me on. As you point out, I've known you for a long time, known you since law school. I won't say how long ago that was, but you were a mentor to me in law school, and I think I picked up a little bit of your contrarian streak, and I think that this case is probably a good example of where that comes out. I have I've been teaching for a long time. In addition to my law practice, I've taught at the music industry program at Loyola University in New Orleans for a number of years. And when I first started teaching, I was putting together my slides for, my copyright class and got to the terminations part, and I was putting together a list of things that terminations didn't affect, right? And so I'm putting the usual things on there, like, oh, well, it doesn't affect works for hire because there's the work for hire exception. It doesn't affect derivative works. And then I got to this part, right? And I'm reading through the various literature on it that said foreign works, right? And I started thinking, I said, well, that doesn't say foreign rights. What does that mean? That doesn't kind of make sense to me. It didn't square. I put it on the slide anyway because I said, well, who the hell am I to question, Bill Patry or whoever I was reading at the time? I just put it on the slide. So I go to teach the class. This is probably 2012. Go to teach the class, and wouldn't you know it, one of the students asks me, well, why doesn't an author get back the right to exploit the work in all countries? Or why would they just get it back in the United States? And I said, damn it, I don't know. I really don't understand it. And from that point, I started really digging into this issue and thinking through it from both like a conceptual standpoint and an academic standpoint. And I developed this belief that I've held for a long time that this is just an incorrect reading of the Copyright Act that has been perpetuated for 50 years. So I have this belief, and around 2018, I get a call from a guy named Cyril Vetter, who at that time was in his mid 70s and wanted to reclaim the rights to a song he had written in 1962 with his buddy Don Smith. And the song was called Double Shot of My Baby's Love. And I had, look, I'm not of that vintage. It wasn't a song that I was immediately familiar with. But everybody that I mentioned it to that is of that vintage had like these fond memories of it, just kind of remembering it's from simpler times, whatever you want to say. So everybody was kind of super jazzed about this. And, oh, I remember that song. So we're having the conversation about, you know, termination and what it would affect, wouldn't affect. And I mentioned to him that the publisher would likely take the position that his rights were limited to the United States and wouldn't have any, and such that the publisher would retain the right to exploit the work in every country but the United States. Well, that made no sense to him either. And he said, well, if they take that position, I'm going to sue them. And I was like, okay, right, fine. Well, fast forward, we submit the termination notice, and I start like basically I take him at his word. I say, okay, we're gonna, if they take that position, we're gonna sue. So I just made it like a hobby of mine to just kind of go and do the research for this issue. in my spare time. I wanted to be ready for when this happened. So when the termination becomes effective, a licensing opportunity comes along. Basically, there was a show in the 1980s that ran on ABC, and they wanted to put that television show on one of the streaming services. And as you know, these streaming services oftentimes are not geo-blocked, right? They're not geolocated. They're just these things are available. Like all things on the internet, in general, there are no geographic boundaries that are imposed on some of these things. So they wanted a sync license for the entire world. And the publisher took the position that his company had to be involved in that sync license because we could only, even post termination, we only had the right to uh, to license the work within the United States. My client Cyril said, "Well, that is not going to fly with me. I think that's an incorrect reading of the termination statute." They disagreed, and so we filed a declaratory judgment. Cyril lives in Baton Rouge. He's born and raised in Baton Rouge. So we filed a declaratory judgment action in the Middle District of Louisiana, seeking to have the court declare two things. The first is related to that termination right, which was to say that following termination, Cyril received back from the publisher exactly what he had transferred away in 1963. Nothing less, nothing more, but nothing less. The second thing, and this is where this is something of a unicorn of a case. As your readers and listeners probably know, the precursor to the termination right was something called a renewal right. Renewal rights have been a feature of United States copyright law basically from the inception, from the 1790 Act. Copyright protection has been split up into two terms. It was initially 14 years plus another 14 years. Then it was 28 or 14 plus 28 or something. Eventually, under the 1909 Act, it ended up being 28 plus 28. So 28-year initial term and 28 years of possibility of additional protection or renewal of that protection for an additional 28 years. Congress made it clear that the point of the renewal right was to give the author or the author's heirs a second chance. How did they do that? They said that only the author or the author's heirs are entitled to receive the renewal right. The previous publisher or the previous owner is not entitled to get the renewal copyright. Only the author or the author's heirs. Why did they do that? Because since the copyright industries have always operated in a way that they acquire rights from creators, from authors, at a time when that author knows very little about the value of their work, right? I write a song, I think it's a great song, but who knows? My publisher acquires it, they go out, they do the commercial exploitation, it becomes a big hit, and they most likely got an incredible bargain for that song or that work, that screenplay, whatever it is. This has been the case for hundreds of years in the U.S. copyright industries, and Congress has recognized this, and so they established this renewal right so that the author or the author's heirs could have a chance to make up for a bad deal initially, right? They would get the rights back. Unfortunately, in the 1940s, there was a Supreme Court case that blessed a pretty controversial practice, which was music publishers and others were requiring writers to assign away both the initial term of copyright protection, but also the renewal term of copyright protection. And that sort of defeated the whole purpose of the protections that Congress intended by the renewal term if publishers could force a writer to assign away both terms of copyright protection at the time of the initial transfer. But there's a catch. If the author does not survive into the renewal term, then that promise to the publisher is invalid. It can't be held against the heirs of the author. In other words, if the heirs were not a part of the initial contract, they can't be held to the contractual terms. And that's exactly what happened in the case of Double Shot. Remember, I told you that it was written by Cyril and Don Smith. Don died in 1972. The renewal copyright vested in 1994. So Don predeceases, and so his heirs were able to get the renewal copyright free and clear of any promise that Don had made to the prior publisher. Cyril was alive, is still alive, and so his promise of the renewal copyright was enforceable. So the copyright gets renewed in 1994. Cyril has to assign his renewal copyright to Winsong, the original publisher. Don's heirs get to keep the renewal copyright. So now, from that point forward, the copyright is split into two ownership interests. The heirs own half, and Winsong, the original publisher, owns half. Well, Winsong, of course, took the position that Don's heirs only had the right to exploit the copyright in the United States. They said they were, even after the renewal, they said that they maintained the exclusive right to exploit Double Shot everywhere else in the world. Fast forward a little bit of time, Cyril purchased the Don's interest in Double Shot from the heirs, from his heirs. So post-termination, Cyril now has Don's renewal copyright interest, or the heirs' renewal copyright interest, plus his termination copyright interest. The question we posed to the court was, what exactly does Cyril have? Based on the renewal copyright from Don's heirs, plus his own termination interest. That's what makes this case so unique, is that it is rare, I mean, not rare, unprecedented, that a court has ever been called upon to decide the geographical scope of renewal rights under the 1909 Act and termination rights under the 1976 Act. And the court held in our favor on both counts. So that's how we ended up where we are, which is that the court ruled that when Don's heirs obtained a renewal right in 1994, which right is now owned by Cyril, that copyright vested in them the right to exploit 50% of that work throughout the world. When Cyril terminated his 1963 transfer, the rights that reverted to him gave Cyril the right to exploit the other 50% throughout the entire world, meaning that Resnick Music Group, as the publisher of the work, the then current publisher of the work, had nothing. And we think that's exactly what Congress intended by both instituting renewal rights and termination rights. That interpretation gives the author the true second chance that we think Congress intended.
The proverbial second bite at the apple,
You got it.
as they said many times. So how did the publisher react to this?
Well, look, the publisher took the position that both this principle of territoriality, right, prevents all of this from taking place. And territoriality is something of a complex subject, but essentially what it means is that, in general, the laws of the United States are applicable within the United States. In general, laws do not have what are called extraterritorial effect. That is true. But when it comes to copyright, the Supreme Court has said that is not like true in all cases. In fact, there was a case that we cited called Kurtzang. And in Kurtzang, the Supreme Court was called upon to determine whether or not the Copyright Act's first sale doctrine applied to works that were made in foreign territories. And the argument there was, well, no, the first sale doctrine is a piece of it comes from the United States Copyright Act. So because the Copyright Act, it can't be applied extraterritorially, it can't apply to foreign works that were made in foreign territories. And the Supreme Court said, well, no, that's not true, right? Territoriality is not that strict when it comes to the Copyright Act. And so our position was the principle against extraterritorial application of the Copyright Act does not mean that a copyright gets splintered into 181 different pieces in every part of the world, right?
Right.
Such that when you renew your copyright or terminate a transfer of a copyright, you only get back a tiny geographical sliver of that. So they were pretty, incensed. I think they were pretty incredulous about the whole thing. And look, in fairness to them, I suppose rightfully so. I mean, I was the one taking a position that was inconsistent with the way that the industry has been operating. But so what, right? I mean, just because the industry has
Right.
operated in a particular way doesn't mean that it's statutorily correct, right? Or that it's legal. So, I mean, I understood where they were coming from, and so we tried to approach this case with a bit of humility to say, look, we realize we're the one that's arguing for an interpretation that is inconsistent with the way that the industry is operated. Having said that, we believe we're right for these reasons, and I think the court probably appreciated a little bit of humility in our approach. So,
Well,
um,
let's talk about what the court. So you had a burden, right? You're moving the Overton window here, right? So you would have a burden to make your case, and the judge seems to have been persuaded. So what did the judge find persuasive about your arguments?
yeah, so let's start with renewal rights, right? Because as I said, termination rights are just the second iteration of renewal rights. Um, so on renewal rights, what the court, there is no statutory text um, that Resnick could rely on. It just the statute is pretty plain and clear. It says that the author or the author's heirs have the right to obtain this renewal copyright, and there's Supreme Court precedent that says that following renewal, the prior owner holds nothing. And what the court said is nothing means nothing.
Right,
It's not a particularly radical approach, right? But what he had to first do was address the argument that the other side was making. That argument was there are actually 181 different copyrights in the double shot song, right? There's not one copyright, there's 181 different ones. Their argument was when when Cyril and Don assigned their rights, what they were doing, assigning those rights throughout the world, upon renewal, because renewal rights are unique to United States copyright law, the only thing that he renewed was the quote unquote United States copyright. The copyright to double shot everywhere else in the world, right? In every single one of these other countries with which we have copyright relations, they said that was not subject to a renewal right. And so Don couldn't, Don's heirs didn't receive that. She found that unpersuasive. What she said was, no, I think that there is one copyright in this song, and that through our treaty obligations, that copyright must be recognized by our foreign treaty partners. But
right,
that these treaties do not create a situation in which a new copyright is born in every single country. Let's take let's say a new country joins the Berne Convention tomorrow, right? Is a new copyright and double shot born in that country
right.
tomorrow? Of course not.
Makes
What
no sense.
happens is that country is agreeing to respect our copyrights in its territories. It's not that a new copyright is born. So she rejected this notion that there's a multiplicity of copyright. And once she did that, the rest of the case for them kind of falls apart. right? Because
Now,
once you realize that there's a single copyright interest, then that really kind of puts a dagger through the rest of the arguments. So
and
on
that single
renewals,
copyright interest, that single
exactly.
copyright interest would be enforceable in other countries based on their local law of
Yeah,
in their
that's the
court
way,
systems,
right?
or
That's
how
exactly
does that
right.
work?
And
Yeah.
so extra, we do not, if a copyright is infringed in France per se, right? Let's just say it's somebody infringes double shot in France. Well, it is the French copyright law that would apply to determine whether or not that infringement occurred, right? That's how it works. Each country uses its own infringement laws because all France is doing is extending to double shot the same rights that it would extend to its own domestic copyrights.
Right.
But in terms of ownership, right, we've never, at least in the United States and to my knowledge, most countries, when they look to determine ownership issues, they don't use their local laws. What they use is the laws of the country of origin of the work. That's the way
Right.
we do it in the United States. And that was our argument here. Look to the laws when this is not a claim about infringement. This is an ownership dispute.
Right.
So whose laws are going to apply? Why would we apply French law to an ownership dispute over an American asset? That makes no sense. We're in court. This defendant is subject to the U.S. court's jurisdiction, and it's an ownership dispute about a U.S. asset. So why would we use French law or British law to determine the ownership? That's what their argument was. I don't know. Well, see, the French don't have a renewal copyright, and so we still own it over there, right? Like that there's a fundamental breakdown for their argument in trying to apply foreign laws to ownership disputes when that's not the way we approach things for foreign copyrights in the United States, right?
Right.
And so why would we do that for our own domestic copyrights? So then on termination rights, there were two issues. One was this issue of territoriality, which is the same thing that we had to overcome around the renewal rights issue. But there's also this statutory language in both Section 304 and 203 of the termination provisions that says that termination only affects rights that arise under this title and do not affect rights that arise under any other state, federal, or foreign laws. So for 50 years, the industry has like hung their hat on that clause to say, well, arise under this title means only the rights that are identified in Section 106 of the Copyright Act, right? And that mention of foreign laws is meant to exclude from termination the right to exploit the work in foreign territories. So that has been the interpretation. And look, they're not alone in that. There was a case in the early 20 or late 2000s called Siegel v. Warner Brothers in the Central District of California that held that. And there have been subsequent cases, subsequent district court cases that have cited to Siegel for that very proposition. So I don't want to make it out as though it is an outlandish position to take. I think it's always been something that reasonable minds can disagree. And in fact, the Supreme Court said in Kurtzang that the phrase arise under this title is kind of an inherently ambiguous term, right? What does it mean in a particular context? And does it have a geographical implication or not? So what the Supreme Court said in Kurtzang is that no, in the first sale doctrine, when it says arise under this title, that does not have a geographical implication to it. And we used Kurtzang to buttress our argument that when that same phrase is used in the termination provisions, that it likewise lacks geographical implications. What it was really intending to say was rights that arise under this title mean the copyrights, like
Right.
mean copyright rights. Other state, federal, and foreign laws refer to things like contractual rights,
Right.
like things that like representations and warranties. So in other words, post termination, it is not as though Cyril's reps and warranties to the original publisher are null and void. No, in fact, they stay exactly as they were because he's not terminating the entire agreement. What he's terminating is the copyright grant. And that copyright grant is the thing that comes back to him. And so, why did we take that interpretation? For a number of reasons, not the least of which is um, when you have two possible ways to interpret a statute, and it is clear that Congress drafted termination rights to benefit the authors. Why would you select an interpretation that harms them? When you have a statute that can be that provides a limitation on a broader right, why would you interpret that limitation in a way that swallows up the right itself? As you know, Chris, a lot of times this foreign exploitation issue is used as a cudgel
Right.
to prevent authors from exercising their termination rights. Why would Congress draft a statute in such a way that it gives the power to the transferee to beat up the author or the author's heirs into preventing them from exercising the termination rights which they gave them? That sort of inconsistency we felt like needed to be exposed, and the court recognized it and said, yeah, given the opportunity to interpret this one way or the other, I am going to choose to interpret it in favor of those for whom it was intended. And we think that's a pretty eminently reasonable position to take.
Right. So, Abby, what's your reaction to this? I mean, what do you, how, as an heir and
I'm,
as an administrator of heirs, what's your
well,
take
it
on
kind of
this?
makes me gleeful. No, I mean, listening to the explanation, for me, it feels like it makes perfect sense. I absolutely agree. Why would Congress choose to provide this kind of, as we say, second bite of the apple, but only, a tiny little bite, not the whole bite? It doesn't make sense. And I mean, I work with many estates, many of which have exercised their US termination rights. And it complicates licensing generally when there are multiple copyright owners and don't need to be. So that's one thing, the complication. The second thing is certainly just from a financial perspective, to be able to control the entire world is a game changer. And it my question is, would this be, let's say this actually is upheld, what happens retroactively? What happens?
Yeah, well, let me first point out, you brought up something I really wanted to key in on because it talks about another reason why this statute shouldn't be interpreted in the way that Resnick and others say it should be. If Resnick is correct and his company retains the right to exploit the work in every country of the world except the United States, that would afford his company veto power over every exploitation of the copyright that cannot be geographically limited to the United States, which, as you know, describes many, many modern copyright exploitations. So let's say that there becomes a personal spat between a publisher and an author or the author's heirs post termination. Is it completely unreasonable to think that the publisher might wield those foreign exploitation rights in such a way to basically harm the author's heirs by refusing to grant rights? I don't think so. I think that if you are going to interpret the statute in a way to say, no, 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 not only do the financial aspect of this, I think is important. Obviously, that's what is driving a lot of the opposition from the industry, is that this is going to have significant financial implications. But think about it from the practical standpoint of exploiting a copyright post termination. Their position would allow them to block your right to exploit the work unless it can be strictly limited to the United States. That cannot be the way that we are going to interpret this statute, such that we give the prior owner not just a financial interest, but literally veto power over so many exploitations of the copyright. What kind of second bite is that,
Yeah.
right? That sounds like, the worst second bite in history to say, oh, well, you can exploit the work if I say it's okay, right? To your question on retroactivity, our position, we did not ask the court to go back and unwind the previous years of exploitations for a number of reasons. But we wanted the court to have a clean shot at the legal rationale here, the legal interpretation, without being, you know, kind of sidetracked by the retroactive implications of this. So we did not ask for that from the court. But what the court held was not that Resnick was divested of anything. It held that he never had it in the first place. So post termination, post renewal, these publishers did not have the rights that they were purporting to have. And so exploitations that were made during that time, right, would be no different than any other infringement, right? Like if you purport to license something and you don't have the rights, then you are an infringer of copyright. So it is not to say that, okay, well, from this point forward, right, like as a matter of law, from this point forward, you can't do anything with the work. I mean, any prior use of the work would have been unauthorized. We didn't seek relief on that, um, you know, because for the reasons I mentioned, but as a general matter, I think that this would have retroactive implications um, for anyone who is, not entered into, is not limited themselves contractually. I imagine
Right.
some people have entered into contracts that would restrict their ability to seek retroactive relief. But yeah, I mean that's got to be a case by case analysis.
I actually have not seen that in among my client base. I can't help but separate this from the MLC termination issue.
Yeah. Yeah.
They're different but very, very similar in
I
terms of
agree. I mean, look, the MLC and the Copyright Office, they had to look at a statute and decide how they were going to interpret the statute, right? What does this derivative works exception mean? It is like, it's not breaking any new ground to say that the Copyright Act is not always a model of clarity on things. And I mean, that's legislation in general. I mean, that's why we have courts, right, to interpret the laws. If it was so clear, then we wouldn't have lawsuits, right? So the Copyright Office had to make a decision about how they were going to interpret the statute. And they interpreted it under the derivative works exception in a way that is most favorable to the parties that the law was intended to benefit. That makes perfect sense to me. And all we have done in this case is to ask for a similar interpretation. So I agree with you. I think that there are the policy, reasons behind termination rights are to benefit authors. And so when a court is called upon to interpret those provisions, we believe and we think that the Copyright Office was correct in its derivative works exception interpretation. And we hope they join us on this too, right? We hope that the Copyright Office will join us in endorsing this interpretation of termination rights because it really is the only way that authors and their heirs will receive the true second bite that Congress intended. Anything less than this is going to result in a massive windfall that Congress never envisioned. And from everything that I can have read, Congress never envisioned a publisher or a copyright owner via transfer maintaining the right to exploit the work in every country in the world other than the United States. That is a massive windfall, and we don't think it's appropriate.
I can tell you from having talked to financiers of rights, and we're kind of in an enviable situation right now. I just anecdotally, where there seems to be more money, more demand than supply, for for people who want in. Those financiers are not concerned about this at all because they look at it as if I bought a catalog and it turns out that they didn't have the rights that I paid for, then either I've quieted that down in my contract to where I'm not exposed, and if I haven't, then shame on me, and I'll just write a bigger check and pick up those rights that I didn't have. I'm not going to be too inclined to just let that go to somebody else because I have written a check and these people have gotten the benefit of it. So don't handle me, let me do me the favor of allowing me to pay you more money, right? And for people who are in the middle of deals, they'll just recalculate those deals. So from a valuation perspective and a financing perspective, it doesn't really change that much.
I couldn't agree with you more, Chris. And I think that what's been the hysteria around, oh, this is going to have massive, disruptive application. I don't think that every publisher feels that way. I
Right,
don't think because the truth is that there are a lot of publishers and finance companies and others who are in the business of acquiring rights post termination.
right.
They will be happy to have the exclusive right to exploit the work throughout the world, right? So there are some publishers who, you know, trade in these rights. And so it will benefit them. Yes, some publishers will lose, some publishers will win. But at the end of the day, that's not really what the court should be concerned about. This whole parade of horribles, which is, by the way, it's totally phantom and speculative, right? Other than
Right.
to claim, I keep hearing this word chaos. I've yet to hear one person explain to me what that chaos will be. What are the implications, right? I've heard people say, "Oh, this is a U.S. court trying to tell foreign courts how to operate." Incorrect. That is absolutely incorrect. A foreign court maintains the jurisdiction and the sovereignty to decide who the owner, who is entitled to enforce the copyright within its jurisdictions.
Yeah.
However, it makes perfect sense that they will look to the United States and the laws of the United States to determine that ownership. And so if the law of the United States is that post termination, Cyril has the right to exploit the work worldwide, then my guess is that they will respect that. Can we force them to? Of course not. But that's this whole business where it's like, oh, America not respecting the sovereignty of other nations. That's bullshit. Sorry, excuse my language, but it's just not it's not an accurate statement.
Right.
It's being used to do a lot of fear mongering that is, simply inaccurate. And I've yet to hear any description of a parade of horribles that has made me second guess anything about what we've done. So, I think it's more of just a financial thing and a lot of table pounding about, well, this isn't the way we do things. And I get that. I mean, I'm not mad at that. I just have never agreed with it, and neither did my client. And so, and what I'm finding, Chris, is that a lot of people have agree with this. They've just been silent on it because they felt we were all kind of walking around the world thinking the same thing, like this doesn't make sense. But everybody was so arrogant about it and would treat you so dumb if you took a position that was contrary to the like admittedly like pretty brilliant copyright minds of Nimmer and Patry and Ginsburg and Goldstein and all these other folks who have written on this topic and take a position that is contrary to ours. It's like there's a little bit of trepidation, like, well, who am I to like go against them? And at some point you just have to get over that hump and say, well, I'm me, right? And I can think for myself, and I don't think that this is right. And I've had a lot of people reach out to me and say, I'm glad finally somebody stood up for this because I felt this way a long time.
They were just first to market.
Right. That's right.
That's
They got to the treatises first.
They were
But
just first. I gotta say, okay, so in terms of the case from, so I have, excuse me, I hold two different perspectives, right? One is that of an heir or an estate of a copyright owner, and the other is somebody who manages rights on behalf of a music publisher. From, excuse me, from the estate perspective, there's no chaos, right? There's no argument for chaos. The only chaos is I may have assigned that US right to somebody and they may have paid me a certain amount of money and now I need to renegotiate with them for the rest of the world. Let's say that's not chaotic. That's, but let's call that an element of chaos in this context. Okay. The second one is the publisher who now has to go back to that rights holder and same thing, has to negotiate and then come up with a figure. Now it is a little more, I'm not a fund. I don't have billions of dollars. If I'm an independent like me, it's if we've sold or bought, it does, the financial part of it does matter. We're not as cavalier. It's not chaotic. It's just about doing a deal. It's about negotiating, what rights somebody holds now that they thought they didn't hold.
And Abby,
And one of
dare
the
I
reasons they
say
thought
that
they
that
didn't
is the
hold those rights, just one of those reasons is because they had it. You talk about a bite at the apple. If they are in a situation where they're about to be divested of rights they thought they had, but it turns out they never had, then the reason that would actually happen would be because they had an opportunity to negotiate away those issues in whatever acquisition agreement they had, and they didn't do it, or they did, it was not done sufficiently,
Mhm.
right? And to me, that's, yeah, sorry, not sorry. Just you send the check to my PO box, right?
Yeah, I mean, and from the publisher perspective, the fact that it's always been done a certain way, who cares? Like, just because it's been done a certain way doesn't mean that was the right way. Let's fix it. We have a chance now to fix stuff. Let's do
Right.
it.
Yeah, I mean, look, we certainly hope that as we go forward on appeal, look, we've got a long road, and um, I don't want to appear overconfident. I think that this really is the beginning of this fight, and we need folks that are listening to this, that are reading, things like music tech policy to get involved. I mean, we need people to stand up. If you have felt this way, or if anything that we've said makes sense to you, then we need you to get involved. We need your voice to be heard as this goes through the appeals process, because assuming it's appealed, and I have no reason to believe it won't be, um, there are going to be a lot of people, a lot of industry folks that come out with all sorts of reasons why this the district court's opinion should be reversed. Um, but we want the courts to hear both sides from this. We want them to hear from the folks who this was intended to protect, the heirs, the authors, right? That's what's important, I think, for the Fifth Circuit, and who knows, maybe even the Supreme Court needs to hear as we're moving forward, is that what would this mean for heirs and authors? That's who the laws were designed to protect. And we want to show them that this ruling will provide the protection that they're entitled to. So I don't think we can sit back and it's not time for a victory lap yet. This is a great result, and we're
No,
we're
right,
super pleased with it.
right,
But this is the beginning of a long process, and we all need to stay vigilant on this one.
right. Well, that's great, man. So Abby, did you have anything for the good of the order that you wanted to add? I think we can call it there.
No,
But
I
this
mean,
has been very informative.
it's so informative. Thank you so much for breaking this down as you've done, because it's so clear to me now exactly what the arguments are. So I appreciate
It's my pleasure. And if anybody, you know, I think it should be required reading in all music business and law school courses to go read Judge Shelley Dick's ruling from July of 24, and when she lays out in really meticulous detail. Let me tell you this much: the people that are out there saying that this judge just doesn't understand copyright haven't read
Yeah.
that
Oh,
ruling.
no, no. Yeah. Right. Yeah.
This
Yeah.
I mean, she gets it in ways that you don't, I mean, she just doesn't get it your way, right? Like, she understands these issues better than I think some people are giving her credit for.
Yeah, I
Uh,
think so too.
and anyone who reads that July of that ruling from on the motion to dismiss from July of 24, you can walk away disagreeing with it, but you can't walk away from it saying, well, this person really doesn't know what they're doing.
Oh no,
It's
no.
just,
And
you
that's
know,
just so people understand, that's the operative ruling, right? It's a little confusing. So how did that end up?
yeah. So they
Working.
initially filed a motion to dismiss, you know, on the grounds that, you know, we were crazy and dumb, right? That was pretty much it. And we laid out in pretty painstaking detail our opposition to the motion to dismiss. And in July of 24, she ruled on the motion. She declined to um, uh, dismiss the case, finding that we had indeed stated a cause of action and that the legal theories were plausible. But she didn't. She probably could have disposed of the case on the merits right then. I get the impression, of course, I don't know, that she was sort of asking the other side to bring her something more.
Right. Sure.
Like if you know, if I'm not going to make this a judgment on the merits
Right.
right now, she could have, but she didn't. So what happened over the next series of months is I filed a motion for summary judgment, basically saying to for all the reasons that were discussed in connection with the motion to dismiss, this is a purely legal issue. There are no facts in dispute, right? So this is a purely legal issue. You've already made a conclusion on these legal things in connection with the motion to dismiss. So now please turn this into a judgment on the merits. And so we had some back and forth. So when she ultimately issued her judgment on her ruling on the motion for summary judgment, she essentially found she incorporated by reference her prior ruling and said to Resnick, you know, you haven't done anything since I made this ruling in July to convince me otherwise.
Right.
Therefore, I'm just going to turn my judgment from July into a judgment on the merits. So it was a
Okay.
little confusing as to how she did it. The ruling from February does not go into great detail. It's only about 7 pages. The substance and the heart of the matter is addressed in her ruling on the motion to dismiss from July of 2020.
Right. And for those reading along at home, that's document 28 in the docket
Give it
that
a read.
yeah, give it a read. It's goes to show you, you got to watch out for those country lawyers, I think anything could happen,
Well, we certainly have nothing but positive things to say about the ruling. We think she hit the nail on the head, and we're certainly appreciative of all the consideration that she gave to these arguments and not adopting what, particularly in the context of the termination rights, going against what the Siegel court had done and some other courts who had, that takes going against other federal district courts and in the Second and the Ninth Circuit is something that is not often done in the copyright context. And
right.
so we certainly appreciated that happening.
That's why we have a Supreme Court.
Indeed.
Well, listen, thank you very much, Tim. And where if people want to get hold of you, where do they do that? What are your
Yeah, well, I'm
coordinates?
in all the usual places on socials, but my law partner and I have a firm called Wells Capel. He's based out of Chicago. I'm in New Orleans. You can go to wellscapel.com and get in touch with me through those means or on LinkedIn or all the usual places.
Okay. And Abby, where do people go to get your coordinates?
It's Abby, ABBY, at northmusicgroup.com.
Okay. Remember,
Hit me
you
up
were
or
warned.
LinkedIn, but email me. I would love to continue this discussion with anybody who wants to talk about it.
All right, then. Well, thank you, folks. And we'll be
Chris, great
posting
to
this
see you
on the
again,
UK
Abby.
policy.
Great to talk.
Likewise.
Right. Thanks, Tim. Take care.
Take care.